Today we're going to deconstruct the work of a true legal architect, a man named James Fitzjames Stevens. So his mission, back in the 19th century, was to tackle a legal system so tangled and confusing that it was almost impossible to learn. He basically decided to redesign it from the ground up, creating a blueprint for evidence law that, believe it or not, we still rely on today. Let's dig into how he pulled it off.
Now listen to that. That's not just some offhand remark. That's Stevens' official diagnosis of English evidence law at the time. He saw a system that was just fundamentally broken for anyone trying to actually study it. He felt you shouldn't have to spend your entire life in a courtroom just to understand the basics. This one sentence, it just perfectly captures the mountain of a challenge he was about to climb.
All right, so here's how we're going to break this down. First, we'll look at the absolute chaos Stephen was up against. Then, we'll follow his mission to bring order to it all. We'll get into his core framework, what he called the 3 pillars, and really dive deep into that all-important idea of relevancy and the rules of proof. And finally, we'll look at the incredible legacy his work left behind.
So to really get why this blueprint was such a game changer, you have to understand the mess it cleaned up. Before Stephen, the law of evidence wasn't a nice, neat system. Oh no. It was a sprawling, disorganized jungle of thousands upon thousands of individual court cases.
Stephen himself pointed out that the so-called law books of his day were less like guides and more like giant encyclopedias. I mean, they collected everything, but they explained almost nothing. They were, in his own words, totally useless for purposes of study. You could find a case, sure, but good luck finding the actual rule behind it.
And here, you can just see the ridiculous scale of the problem. We're talking about absolutely massive books. A leading text, Taylor's on Evidence, was almost 1,800 pages long and cited something like 9,000 different court decisions. Another one, Roscoe's Digest, referenced over 11,000 cases. Now, just imagine being a law student trying to find one clear rule in all of that. It was, just as Stevens said, almost impossible.
Okay, so into this chaos walks our architect. Now, James Fitzjames Stevens had already done this before. He had successfully written a clear code of evidence law for India, the Indian Evidence Act of 1872. So he knew, for a fact, that it was possible to bring logic and order to this mess, and he wanted to do the exact same thing for England.
And this really gets to the heart of his mission. Stephen's goal wasn't to just write another huge book. It was an act of, radical organization. He wanted to take that mountain of cases and distill it all down into a set of clear, logical, and, most importantly, understandable rules.
And here is, right from the man himself, check out those key words, separate and reduce. First, he wanted to pull the rules of evidence out from all the other areas of law they were tangled up in. And then he wanted to shrink them down into a compact, logical system that a student or a lawyer could actually learn and use. So, how in the world do you build a whole legal system from scratch? Well, Stevens started by asking 3 incredibly simple but really profound questions. And these 3 questions became the pillars, the very foundation for his entire structure.
I mean, this is just brilliant, isn't it? It shows you exactly how his architectural mind worked. First, what are we even allowed to talk about in court? That's all about relevancy. Second, how do we present that information? Is it a document, a witness? That's the rules of proof. And third, who's responsible for bringing the evidence and how do they do it? That covers things like procedure and the burden of proof. Literally, every single rule of evidence fits neatly under one of these 3 questions.
All right, let's start building this thing, starting with that first and arguably most important pillar. What facts are even allowed in the courtroom? This idea of relevancy is basically the gatekeeper for all evidence. If a piece of information isn't relevant, it doesn't get in. End of story.
Okay, so first we have what are called the facts in issue. The easiest way to think about these is that they're the ultimate questions the court is trying to answer. So in a theft case, a fact in issue would be, did the defendant actually take the property? Or in a business dispute, did both sides really agree to this contract?
Then you have relevant facts. Now, these are the building blocks you use to make your case. They aren't the ultimate question themselves, but they're the clues, the pieces of evidence that let a judge or jury draw a logical conclusion about those facts in issue. So, for example, finding the defendant's fingerprints on the stolen wallet, that's a very relevant fact. So what's the test for whether something is relevant? Stephen came up with this fantastic common sense definition. Basically, does knowing fact A make fact B more likely or less likely to be true? It's not about 100% certainty, it's about probability, based on how things work in the real world. This beautifully simple idea is the starting point for all evidence. But, and this is a huge but,
Just because something is logically relevant doesn't automatically mean it's allowed in court. Stephen laid out 4 major categories of evidence that the law almost always kicks out. You've probably heard of some of them, like hearsay or opinion evidence. Now, these things are usually excluded not because they're totally illogical, but because they carry a huge risk of being unreliable, confusing the jury, or just being plain unfair. It's a critical balancing act between logic and justice.
Okay, so we figured out what facts we can prove. Now let's move on to Stephen's second and third pillars. How exactly do you prove them, and who has the job of doing it?
So, Stephen splits the how into 2 main types. You've got oral evidence, that's someone testifying in court. The absolute key rule here is that it must be direct. That means the witness had to have seen it, heard it, or sensed it themselves. You can't get up and testify about what your friend told you they saw. That's the core of that hearsay rule we just mentioned. And then, of course, you have documentary evidence. Pretty simple, that's documents.
And he clarifies this even further. Primary evidence is what we call the best evidence. It's the original document itself, the real deal. Secondary evidence, like a photocopy or just someone describing what was in the document, is usually only allowed if the original is gone and there's a good reason for it. The whole system is built to prioritize reliability.
And finally, we hit that third pillar, the actual procedure, the rules of the game. The core principle here is simple. If you make a claim, you have the burden to prove it. On top of that, witnesses have to be legally competent to testify, they have to swear an oath to tell the truth, and their story is tested through a really structured process of examination, cross-examination, and re-examination. It's all designed to make sure the evidence is presented fairly and properly challenged.
So after all of this architectural work, what's the bottom line? Well, it's nothing short of a complete revolution in how we think about the law.
This right here is the ultimate achievement. Stephen took evidence law from being this scary, chaotic jungle of cases and transformed it into what it should have been all along, a connected, logical system of rules you could actually understand. He gave it a spine, a structure, something that could finally be taught, learned, and applied.
You know, Stephen himself loves to use this quote from the great Lord Mansfield because it just perfectly nails his entire philosophy. The cases aren't the law, they're just examples of the law. The real law is the set of general principles that ties them all together. This idea was the foundation for his entire project, elevating the principles above the messy particulars.
And that leaves us with this one last thought to chew on. All these concepts we just walked through, relevancy, hearsay, the burden of proof, they aren't just history. They are the absolute bedrock of evidence law today. Stephen's blueprint wasn't just some dusty old book. It was so profoundly logical, so well designed, that his core architecture continues to shape how justice works in our courtrooms, right now, to this very day.